Hello everyone, welcome to the LLB First Semester Classes by Krishna Tutorials. This is the second introductory demo class. So this is me, Naman Sinha. I am the Associate Editor of Dakshin Samachar Hindi Weekly. I am also founder and convener of PLC Law Students and Alumni Community, an official LinkedIn group. So in this group I am trying to connect the students and alumni on LinkedIn with each other. I have also organized a webinar on how to excel in law school. So I am also the associate editor of Hyderabad Student Law Review Journal, which is annual magazine which contains various articles on contemporary legal issues. I have also been the associate editor of 4 Hindi literature books. And lastly, I am an aspiring career coach. So if you need help with CV making, review, cover letter review, article writing and publishing, internship guidance like when to start doing internship, where to do internship, and at what time, what stage, which internships you must be doing, and interview preparation or any other thing, then you can reach out to me. I'll help you or get you the help you need free of cost. So next, my 4 articles have been published on various legal issues such as dissenting opinion, right to speedy trial, compulsion of witness, and buyback of shares. So today I am going to be taking a demo class on contracts law 1. But before that, I'll be talking about how we will be going through the syllabus, how we will be learning the various topics today. So firstly, the semester exams for law subjects are very different from regular exams. You would be writing many articles, case laws, sections and amendments. So you must have to remember about hundreds of case laws, articles, amendments and sections, mostly in constitution, criminal law, etc. So I'll be showing you how to use a new technology for remembering all this, and you would have them on your fingertips, all the articles, sections and amendments. So firstly, let me show you the technology which would be provided to you. So this is an app. I'll be sharing you all these questions. So let me open this Krishna's tutorial. You will be getting like this only. After you open, you will get a question like this: SR Bommai versus Union of India. So this is a case law. So when you select the KT Krishna tutorials, you will be getting a question like this, and then you will be getting a show answer option here. So what you must do in this app is that you must see the question, then you should think if you know the answer, and after you have thought about it, then you must select the show answer button. It doesn't matter whether you remember it or not, whether you are right or not. You have to revise through this app, and over time it would get feed in your long-term memory or short-term memory based on how many times you have been using and at what intervals, but it will get feeded into your memory and you will be able to remember everything. So this is the answer. You will be provided this answer when you choose the show answer tab, and again there will be these 4 options below. So when answering the question, it will based on how much time it has taken you for answering the question. Like if you didn't answer the question, you must select this option. If you had a little difficulty but still got the answer right, then you can choose this option. If you got the answer right easily, then you can choose this option. And this last option is for those people who are preparing long term. Like these 3 options will be helping you in exams, and this one is for long term remembering and recalling. Like if you are preparing for an exam 2 months or 3 months back or 6 months back, so this 4th option is for that. So if you get the answer wrong, you will select this option, then the question will be shown to you again within 1 minute or whenever it can be shown, and same for the other options also. So you must use this app until you remember everything. You must be in a position to answer everything before the exam itself. Like if you are going for an exam tomorrow, then you must use this app 4-5 times a day before the exam, and when you are going to write the exam, you must check if you are able to recall everything, if you remember everything. And by way of this process, you will be able to write hundreds of articles, sections, amendments and case laws in the exam. I have been using this app for 2 years and I have not been disappointed. Some days ago I used this app for jurisprudence also, and there is a question in jurisprudence, what are rights, and explain some types of rights. So there were about 28 types of rights in the answer, like positive right, negative right, perfect right, imperfect right, right in rem, right in personam, and and many more, legal right, constitutional right, etc. So I was amazed that I had recalled about 28 rights in the exam, and I filled 10 to 12 sides of the paper. So that is how much knowledge you can retain with the help of this app. So this will be provided to you on a daily basis. The material will also be given to you. You just need to open the app, you need to upload the material, and you can start learning and revising. This will be provided to you in the app itself. So this was the technology. So but this app is only for remembering the subheadings, case laws, articles and sections, etc. But for the concept, you will need to understand everything. Like the things in the app will help you to remember and recall the subheadings. But the portion in the concept, like below the subheading, you would need to understand the subject and then fill it up by yourself. So then you won't need to do anything else. Once you have understood the concepts, once you have remembered the subheadings and the article sections, etc., then exam will be a joke for you, and you will be prepared to write even judiciary exams like this. So next I will be moving on to the concept. So today we will be dealing with the contracts. So in India we have the Indian Contracts Act of 1872. So many laws were prepared by the British, like Indian Contracts Act, Indian Evidence Act, Indian Penal Code, etc., etc. So this act came into force on 1st September 1872. So the objective of the Contracts Act is to ensure that the rights and obligations arising out of a contract are honored and legal remedies are made available to those who are affected. So what this means is, like, you and me, we enter into a contract. I want to sell you 100 bags of rice. We agree that you will pay this price and I will supply you the rice. But after I supply the rice, when I ask you for payment, you tell me that who are you? When did I make any contract with you? So this may have been the situation in 1872, or else there was no effective remedies. So this act, it ensured that such situations don't happen and there is no breach of contract, and the parties are protected by the courts. So this act was made to ensure the rights and obligations. So what are the rights? So when I sell you 100 bags of rice, I have the right to get payment from you. On the other hand, the other party will have the obligation to make that payment. So rights and obligations go together. My right is your obligation and your obligation is my right. And your right is my obligation. So they go hand in hand, and this contract also provides remedies. So the remedies may be specific performance or damages or compensation, which will be made available if you are affected. So next, moving on to the next slide. So now we move on to the definition of contract. So contract is defined under section 2H as an agreement enforceable by law. The important term here is enforceable. Enforceable means you can approach the court of law and ask for it to be performed or ask for compensation or other legal remedies. But all agreements are not contracts because of some defect. The main thing here is enforceable. And all the contracts are agreements, but all agreements are not contract. When the agreement has the property of being enforceable, it becomes an contract. So this is defined under section 2H. Next we move on to agreement. Agreement is defined under section 2E as every promise and every set of promises forming consideration. So what is the promise? Like I explained in the other example, A wants to supply 100 bags of rice. So A promises to supply 100 bags of rice and he will get payment from the other party. Then that is this other set of promise forming the consideration. What is the consideration? He will be getting the money, the other party would be getting the goods. So the promises they are forming for each other is known as agreement. And when this agreement is enforceable, it becomes a contract. So next, for a promise there needs to be an offer. Offer means, like I just said, A wants to sell 100 bags of rice. He will convey his intention to B. B, I want to sell you 100 bags of rice. This is an offer. And when the offer is accepted by B, then it becomes an agreement. And then after agreement, if it is legally enforceable, it becomes a contract. As I just said, all contracts are agreements, but not all agreements are contract. And contract is defined under section 10 as all agreements made by free consent of parties competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. So these are all the essentials: free consent, parties competent to contract for lawful consideration with lawful object and are not hereby expressly declared to be void. So section tells us what is a valid contract. So next we look at the essentials of a valid contract. So the first essential is a valid offer and acceptance. It is defined under section 2A and 2B. So for an agreement, there must be two parties. One person cannot make a contract with himself. There must be two parties to the agreement. One party will make the offer and the other will accept it. And the person making the offer is called the offeror or proposer. And the person to whom it is made is called offeree, proposee. If the offer is accepted, then the offeror, proposer will become the promisor, and the offeree and proposee will become the promisee, and the offer will become a promise. And for the offer, for the agreement, the terms of offer must be definite and acceptance must be absolute and unconditional. If you set out some terms before you accept the condition, then it will become your new offer. It will become a new offer, and then the other party would have to accept. So that's why you must accept it absolutely and unconditionally. Otherwise you can make a counter offer. It must be definite. You cannot make vague agreements. You cannot have any vagueness, like you will ask B to marry C and I will give you something. Something here is not defined, so it is a void offer because it is not definite and cannot be made definite. Next, the acceptance must also be according to mode prescribed and must be communicated to the offerer. So the acceptance must be according to mode prescribed. So like if you are emailing each other and then if you send a post making the acceptance of the offer, then it is not valid. If you are emailing, then you must fulfill the acceptance by email or the way which is being used by the parties. You cannot make a post and claim that you have accepted the offer, now fulfill your duty. it must be made in the same mode prescribed or being used. Next we move on to the second essential. So before that we have a Latin maxim, consensus ad idem. This means meeting of the mind. The offerer and offeree must, the parties to the offer must should accept the terms of contract in same sense. Like there must not be any differences or ambiguities between the two people. They must have the same sense. They must think about the same issue, same thing. Next, the second essential is intention to create a legal relationship. So the intention of the contract is that there will be legal consequences if there is a breach. So the parties must have an intention to face legal consequences, to have a legal relationship before entering into the contract. When the two parties enter into an agreement, their intention must be to create a legal relationship. If there is no such intention on part of the parties, then there is no contract. The intention here differentiates legal and social agreements. Social and domestic agreements do not contemplate legal relationship. As such, they are not contracts. This will be explained further in the examples. So these two cases will be explained, which are the example of social arrangement and the difference between social arrangements and legal agreements. So in this case of Balfour versus Balfour, a husband and wife were enjoying a vacation, but the wife took ill and was advised not to travel. The husband, who is defendant, had to return to his work, so the husband agreed to send 30 pounds every month. But after some time, due to differences and separation, the wife approached, the amount stopped. Then the wife approached the court, which held that such agreements are not contract and they are just arrangement between husband and wife. So in this case, what happened was that they were living as a wife and husband, and they agreed as both wife and husband. So it looked like a social arrangement, a arrangement between husband and wife. But if there was something which defined their intention of being in a legal relationship, or which showed their intention to be in a legal relationship, then it would have been a breach of contract. But as there was no such thing and they didn't intend to have legal consequences, it was considered as a social arrangement. Next we move on to the case of Merritt versus Merritt. So in this case, Mr. Merritt and his wife jointly owned a house. Mr. Merritt went to live with other women. They made an agreement. The important word here is signed, that Mr. Merritt would send a $40 monthly sum, and if Mrs. Merritt kept up the monthly mortgage payments, would eventually transfer the house to her. When the mortgage was paid, Mr. Merritt refused to transfer the house. So in this case, they had an agreement. They were living separately. So this all showed the intention that they intended to have a legal consequence. So and here they are talking about agreement because the fact of the issue was whether it is an agreement or a contract. So here it is being talked as an agreement, but here it is being talked as a contract. So the court held that it was a contract, and the nature of dealings, that the fact Merritt were separated when they signed the contract, allowed the court to assume arrangement agreement was more than a domestic agreement and they intended to have legal consequences. Next we move on to the third essential. Lawful consideration. So this is defined under section 2D and contained under 23 and 25. So an agreement to be enforceable by law must be supported by consideration. Consideration here may be an act, a benefit, or the promise to abstain from doing some act, or monetary compensation or monetary benefit. So consideration means some advantage or benefit moving from one party to another. In simple words, it is something in return. An agreement is enforceable when both parties give something and get something in return. Like if I give you 100 bags of rice, you will get 100 bags of rice and I will get money. It may be an act or abstinence or promise to do or not to do something. It can be past, present or future. And lastly, it must be real and lawful. So lawful here means like you can't give some consideration for an unlawful object or which is opposed to public policy or opposed to morality, etc. Next, we have the fifth essential, that is competency or capacity of the parties. So for entering into a contract, the person must be of age of majority. So age of majority is 18 years and it is defined under the section 3 of Indian Majority Act of 1875. Then he must be of sound mind. Sound mind here means he must not be insane, he must not be drunk, or he must not have any other illness which causes unsound mind. And lastly, he must not be disqualified from contract by any law to which he is subject. So criminals cannot enter into contract. Then we have insolvents. Insolvent is a person who has been declared by a court of competent capacity as insolvent because he failed to discharge his debt and he doesn't have any money left. So he will be declared by a court as insolvent and he cannot enter into contracts with other people. So this was done to ensure that the other people are protected, because he doesn't have any money, he cannot perform many things. So that's why insolvents are also disqualified from entering into contracts. Like for example, if someone gave you a loan but you couldn't repay it back and you were afraid of danger to your life, then you can approach a court and get an insolvency certificate. The court will grant you the insolvency but will prevent you from entering into future transactions. Next we have the sixth essential, that is free consent, defined under section 13 and 14. So the parties are said to be of same mind when they agree about subject matter in the same sense and same time. The consent of parties must be free. So when the consent of an agreement is caused by coercion, undue influence, fraud or misrepresentation, the agreement is voidable at option of party whose consent was caused so. So what is coercion? Coercion means any act which is illegal under any other law. Like if you put a gun to someone's head and say, do this act or else I will kill you, then that is coercion. So coercion is any act which is illegal and to compel the other person to do some act by making him fear by this illegal act, by making him afraid by this illegal act. Next we have undue influence. So undue influence means when you have a relationship with the other person and you use that relationship to get some benefit from him. Like if a grandson asks his grandfather to give away all of his property to him and don't give any to his other grandsons and other children, then that is undue influence. Then third is fraud or misconception. So fraud is deceiving the other person by in some way to get him to enter into the contract. Then next we have misrepresentation. Misrepresentation means making false claims about quality, quantity, price, potency, etc. just to get the other person to enter into the contract. So when an agreement is caused by these four things, then it will be voidable. What is voidable? So there are three types of contracts: valid contracts, voidable contracts and void contracts. Valid contracts means it must be legally enforceable and have all the essentials which we are just talking about. Next, voidable contract means when an agreement is caused by coercion, undue influence, fraud, or misrepresentation, then the person has a choice whether to allow the whether to allow the contract to proceed in the future or to make it void. It is the option of the party whose consent was caused so. Like if I held a gun to your head and if you still want to continue with the contract, you can continue. So this is the basic difference between voidable and valid contracts. And then void contract is void ab initio, which means it is void from the beginning because of some defects. So that was the introductory demo course by Krishna Tutorials for LLB first semester. If you want to purchase the course, then you can go to the Krishna Tutorials app, download it, and you will find the course here. So it is priced at 876 rupees, and you will be provided the new technology app which will help you retain the memory, remember everything at the time of exams, all the amendments, articles, case laws and sections. And then you will be provided material. You will be regularly every day 1 hour class will be taken on the 4 subjects of constitutional law, contract law, law of torts and family law. You will have live and recorded sessions, you will have doubt clearing sessions, and you will have flashcards to revise, which is the new technology, and the material will also be provided for that flashcards. So you can buy the course for 899 rupees. Thank you.